All right, might be harsh to some. A North Carolina public defender has been ordered to be able to spend 5 days in jail. So a Guilford County judge says that Juan Zugluaga was repeatedly disrespectful and argumentative following a ruling in a criminal case. So court documents show that he was instructed multiple times to remove himself from the courtroom. He was later found in criminal contempt of court. So he was issued a $500 bond and has since filed an appeal in this case. Let's talk about it, though. Joining me now is Chief Legal Analyst Clive Rhodes. I mean, when you look at this and you hear all of a sudden he kind of lost it, I mean, what are your thoughts?
Well, I mean, that's the assumption. I wish there was video so we could see exactly what happened in the courtroom. I've been practicing for a long time, and I can tell you that I have never seen it occur where an attorney was held in criminal contempt. Seen a number of defendants, seen a number of individuals that were members of the public in the audience watching in the gallery,
right,
but never an attorney. I've had one instance where an attorney told me a story of how a judge almost held him in contempt. But the standard in North Carolina is pretty simple, that for the judge to hold you in contempt, you have to have interrupted the proceedings to the point where they can no longer proceed. So this hearing is over. This individual judge rules against him. He's not happy and frustrated with what happened, and it sounds like there was back and forth. The judge said in their order 4 or 5 times he had an opportunity to walk away, to leave the courtroom. And so those types of outbursts, if court is still in session, obviously aren't allowed. They're against the rules of professional conduct. You want to show candor to the court, even if you disagree with the judge's decision. Now, if you're just being disagreeable, if you're arguing and advocating for your client, that's not contempt. But if you're saying, hey, judge, I know you told me that you're ruling against my client, I disagree, and it's over right there. But if you continue to go after the judge, the contempt is all you can have. Most judges don't want this to happen. Most judges will warn you, because that's also something that you'll want to have, is a warning to let them know, hey, I'm about to hold you in contempt. So that's where you get that 4 or 5 times to let them know that, hey, this didn't happen off of one conversation or one comment.
So how much discretion does a judge have then to decide? Because they were saying in this case in particular that he was argumentative, that he was disrespectful. So kind of give us kind of
sole discretion. It's their domain. In that box within that room, that is their domain. If you walk into that courtroom, it is the judge's courtroom, and so what they say goes, obviously within the law and how the statute prescribes. So you can't hold someone in contempt just because you don't like the tie they're wearing. You can't hold them in contempt just because they're sitting there advocating for their client. But again, if they are doing something like, derogatory, if they're being belligerent, if they're not listening to instructions that you give them, you're asking them to let you finish your statement and they're cutting you off. Judge may allow that one time and correct you, but then if it's multiple times, they'll say, hey, if you do that again, I'll hold you in contempt. And then if you go after that, I think most judges will hold and be restrained because they want to ensure that they don't have a situation like this happen where they have to put a person that's an officer of the court, a public servant, now behind bars while trying to do their job. So I'd like to have seen the incident play out, but from the judge's order, it seemed like there were multiple times where they were trying to avoid this from happening.
Knowing what you just laid out, to me, I just think, and being inside of a courtroom, just as being a reporter, I mean, it's intense. You have to be able to follow the rules. We all know that. So a case like this is kind of surprising.
Oh, this is rare. I mean, this does not happen.
Right.
It's extremely rare that an attorney will be held in contempt. I can tell you the story about the one public defender here in Mecklenburg County. He was advocating for his client, not being disrespectful, and the judge said, hey, if you say something else, I'm going to lock you up. He was ready to go to jail for his client, starts taking his watch off and his jewelry off, and says, Your Honor, I'm ready. And the judge stepped back because in that scenario, the judge didn't have the statute on their side. He wasn't being argumentative. He wasn't being defensive or in a position where he was trying to disrespect the court. He was trying to advocate.
Right.
And if you feel like you're advocating, a judge holds you in contempt, that's going to be an issue for the judge, not for you.
Holly Frost, appreciate your insight. Thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.